Generally, a person must be of sound mind to possess testamentary capacity to execute a valid will. A person lacks testamentary capacity and isn't of sound mind when he or she suffers from an insane delusion that materially affects the disposition of property in the will. In the 2000 case Breeden v. Stone, the Colorado Supreme Court considered whether a man had testamentary capacity to execute a valid holographic or handwritten will prior to committing suicide. At age 13, Spicer Breeden inherited $2 million from his family's fortune when his mother died. As an adult, Breeden used copious amounts of cocaine and racked up speeding tickets as well as criminal convictions for driving under the influence. Additionally, Breeden often experienced strong mood swings and was excessively worried about threats against himself and his dog from government agents, friends, and others. In March 1996, at the age of 36, Breeden and his friend got into Breeden's car after a day of drinking and doing drugs. The two started speeding down a Denver highway and, while weaving in and out of traffic, slammed into the back of Greg Lopez's vehicle, killing Lopez. Breeden and the friend stopped briefly and then sped off, leaving the crime scene. The two later returned to Breeden's mansion, switched vehicles, and proceeded to go bar hopping in Denver. In the days that followed, Breeden barricaded himself in his home and watched television coverage of the accident while drinking alcohol and snorting cocaine. When the police came knocking on his door, Breeden turned a gun on himself and committed suicide. The police then entered the home and discovered a handwritten note which purported to leave all of Breeden's property to Sidney Stone, his so-called business manager. However, 5 years prior to his death, Breeden had executed a formal will, which left his property to persons other than Stone. Subsequently, Stone filed a petition to admit the handwritten note for probate as Breeden's will. In response, several individuals, including Breeden's father and sister, objected, claiming that Breeden didn't have the testamentary capacity to execute the will. Specifically, they argued that Breeden suffered from insane delusions at the time he wrote the note based on his intense mood swings and constant fear of threats. Following a bench trial, the court disagreed and admitted the note to probate. Breeden's father and sister appealed, and the Court of Appeals affirmed. The Colorado Supreme Court granted cert.